Oh, yeah. That's why we're like. Yeah, so I like, well, how do I make this work? I'm gonna go for that. Just don't do that. There you go.
I'm gonna reserve my time, so.
I mean, I'm in order. I approach it.
Oh, yes.
I touch it.
Yes.
How you doing? It's good to see you. It's fine. Once a person came to know that that was being told that I needed to pick up on my story. So it's oh, okay. There were some messages. I have a meeting to discuss. I know you're closing argument. I was kind of hoping to get me. I appreciate it. Thank you so much.
All right, everyone, good morning. This is going to be the order of court today. As soon as we have all the jurors present, we're going to do closing arguments. So we may be in the middle of the hearing and we have to break because we have closing arguments for this jury trial. Today is Friday. Everyone put some patience in your pocket and it's going to be a great day. Just use it as needed. I do not have the docket for the day. Let me see if I can find it. Here we are. Today is the 17th. Curtis Williams. Brandon Guzman is in custody. Samantha Richards. Juan Ratana is in custody. Philip Diller. Thank you. Jesus Romial, I believe he's going to be in misdemeanor court first. Juan Aviles. Thank you. Marcelino Scott. Timothy Hernandez. David Newman. Michael Ruano is in custody. Jonathan Boyd. Again, no relation. Wilbert Villarreal is in custody. Brandon De Hoyos custody. Christian Segovia.
Your Honor.
Council's
Felix Apolinar.
President Judge, I don't know that he made it to the docket yesterday. We didn't get notice of the thing, so we didn't get a chance to notify him. So I don't know if he's here this morning. I'd have to see him again.
All right, Ross Kuko and Roland Davis and Jay Delgado's in custody. Jonathan Crail. All right, could I see the file on Felix Apolinar? Thank you. No, he was supposed to be here yesterday.
Yes, ma'am.
And I'm telling, I know you probably know this, counsel, but this is an indicted case.
Yes,
so they received notice through the mail.
Okay.
At their last known address.
Okay. I just, we haven't been able to get a hold of the judge, and I want to be frank with the court that we, for whatever reason, we didn't get notice of the setting timely, so we could send a letter out for him. So I just want to make the court.
No. This case is recalled. He was supposed to be here yesterday.
Yes, ma'am.
So it was recalled today to give someone a chance to get him here.
Yes,
But he was actually supposed to be here yesterday and he would have received notice. Can I have a prosecutor, please?
Yes, right here.
All right, thank you. Court is calling 2023 CR 0288, State of Texas versus Felix Apolinar. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Raymond Bill, Your Honor.
All right, this hearing was called on February 16th yesterday. It was recalled today to give a chance for the defendant and the defense attorney to appear. Neither, I'm sorry, the defendant is not present today. And Deputy Laura is making an announcement outside. Just a moment.
And I can only represent to the court that we attempted to try and reach him, Judge, as we became aware of the setting, but we haven't had any contact with him since yesterday's setting, nor this morning. But I'll make every effort to try and bring him in.
All right, we're gonna see if if she's able to contact him if he's out in the hallway.
Yes, ma'am.
It appears that some people are walking in with her. We shall see who they are. Felix Apolinar? No. Deputy Laura, did you make an announcement?
Yes, Your Honor, and there was no answer for Mr. Phoebe. Polinar.
All right, I'm sorry, State. It's Friday.
Thank you. The state's requested a bond forfeiture. Your Honor.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Yes, ma'am.
All right,
Appreciate
thank
that,
you.
Your Honor. I had one other on the document, Mr. Cusco. He's in custody in PR.
All right, could you bring Mr. Cuscos out, please? Thank you.
Thank you, Judge.
You're welcome.
Cusco.
Are all the shows? Not yet.
Jonathan Boyd. Oh, come forward. All right, what is happening with Mr. Boyd?
Mr. Boyd is going to be a trial, Your Honor, so we're on that track.
All right, State, how long do you expect this trial to last? It's an indecency contact.
Probably 3 days.
All right, Ms. Ferguson, I need a jury trial date for Mr. Boyd. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll have to plead open to the court. Do you understand?
Yes, ma'am.
Excuse me, Jason, do you have an idea how long this, Jason 2.0. Do you have any idea how long this motion will last with Mr. Mauer?
I'm not planning for it to last very long, Judge. I would say maybe 15 minutes.
All right,
We don't have witnesses, it's just argument.
all right. Do we still have the missing juror?
I couldn't go check.
All right, if we still have the missing juror, if you can call Mr. Mauer, we'll take that up. That way you can go to your appointment.
Sounds good, Judge.
All
Appreciate
right, but she's gonna check to see if everyone's here. Oh, everybody's here.
it.
Yeah,
Don't call
don't call him. All right, what date, Ms. Ferguson? All right, it's gonna be April 11th. And Ms. Ferguson will give you a reset form. Court is going to call
You can have a seat.
2021 CR 7554, State of Texas versus Aaron Trevino. Can I have the parties announced for the record, please, for the state?
Brittany Mitchell for the state.
Defense,
Alfonso Cabañas for the defendant.
and you're Mr. Trevino. All right, you may be seated. All right, so the state had rested in the state, I'm sorry, in defense, you had a motion for directed verdict, is that correct?
Yes, Your Honor, we did.
All right, the court will hear your argument.
Oh, Judge, yes, so the defense motion for directed verdict is based on the fact that the state did not meet all of the elements. The element of a finding of a deadly weapon was not met beyond the benefit of the doubt. There was no evidence or testimony whatsoever that, first of all, a lighter was used. Second, even if there had been testimony about a lighter being used, there was no evidence whatsoever or testimony that the lighter in the manner of its use and intended use was used as a deadly weapon. Therefore, Judge, we're urging this court to grant this motion for directed verdict.
All right, state.
Your Honor, there was testimony from the victim herself. She saw the lighter. She had been drenched in gasoline. At the time she was drenched in gasoline, she was not on fire. It was not until he lit the lighter that the spark initiated the flame, which caused a serious bodily injury. The fact that it is a deadly weapon is shown through the evidence itself. The fact that it did cause serious bodily injury, and she did almost, like she did, Dr. Lundy testified that she could have easily died from this. Additionally, there was testimony from Sergeant Mendez. I asked her when she was in her investigation, and she decided to walk a warrant for aggravated assault with a deadly weapon, SBI, what the deadly weapon was in this case, and she affirmatively said the lighter was the deadly weapon. Your Honor, there doesn't have to be any expert who says a lighter can cause a flame. The facts of this case and the circumstances clearly show that it was a lighter that was used, and in the manner that it was used, it was not only capable, but it did cause serious bodily injury.
All right, defense, it's your motion, so I'll give you last word.
Yes, Judge, just finally, that there's been talk about a lighter, but there's been no evidence presented that a lighter was found. There's been evidence by the states where Mr. Gina Briones initially told law enforcement, I was smoking a cigarette, I tripped, and I lit myself on fire. Then she mentions a lighter. Then she says, Mr. Trevino had the lighter. No, I had the lighter. But at the end of argument, there has been no lighter found. There's no lighter presented. And there's evidence that it may have been a cigarette, not a lighter, which again was never found. Therefore, Judge, did not be one of the elements we're asking for. Motion to break the first.
All right, that will be denied. All right, if you can bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, state has rested. That's where we stopped off yesterday. Defense.
Your Honor, the defense rest and we have no witnesses.
All right, the state, do you close?
Your Honor, the state closes.
Defense, do you
This
close?
is all your Honor.
All right. And state and defense, could you approach briefly, please? All right, ladies and gentlemen, what I'm going to read to you now is what's called the charge of court. Don't worry about memorizing it because you will receive it when you go back to deliberate. Charge of the court, members of the jury. The defendant, Aaron Trevino, stands charged by indictment with the offense of aggravated assault causing serious bodily injury with a deadly weapon against a person with whom the defendant has or has had a dating relationship alleged to have been committed on or about the 23rd day of November 2020 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. 2, a person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of aggravated assault causing serious bodily injury with a deadly weapon against a person with whom the person has or has had a dating relationship if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault and causes serious bodily injury to a person with whom the defendant has or has had a dating relationship. Three, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Dating relationship as described by section 71.0021 of the Texas Family Code means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. The existence of such a relationship shall be determined based on consideration of the length of the relationship, the nature of the relationship, and the frequency and type of interaction between the persons involved in the relationship. A casual acquaintanceship or ordinary fraternization in a business or social context does not constitute a dating relationship. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that its conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of November 2020 in Bexar County, Texas, the defendant, Aaron Trevino, did intentionally, knowingly, or recklessly cause serious bodily injury to Regina Briones by lighting Regina Briones on fire, and during the commission of said assault, Aaron Trevino used a deadly weapon, to wit, a lighter that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Regina Briones was a person with whom Aaron Trevino has or has had a dating relationship as described by section 71.0021 of the Texas Family Code, then you will find the defendant guilty of the offense of aggravated assault, causing serious bodily injury with a deadly weapon against the person with whom the defendant has or has had a dating relationship as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. You are instructed that if there is any evidence before you in this case regarding the defendants having committed an offense or act of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any were committed. And even then, you may only consider the same in determining the nature of the relationship between the defendant and the complainant in this case, if it does, and for no other purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into any consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service or any text or instant messaging service or any internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, LinkedIn, YouTube, Instagram, Google, or Twitter to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in the evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous agreement, if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty and must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty on the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. During your deliberations, if you request that testimony be read back, under the law, I cannot read testimony back to you generally. You must have a dispute regarding the testimony about which you are asking, if you are, and if so, you will need to specify exactly what you are in dispute about. If you have a disagreement about a certain witness's testimony and you specify as to what you are in a disagreement about with regard to the statement of any witness, then you may, upon application to the court, have read to you from the court reporter's notes just that part of the such witness's testimony or the particular point in dispute and no other. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County. Suitable forms are attached. Are both parties ready for closing arguments?
We're ready, Your Honor. We would reserve our time.
All right, defense, are you ready to proceed?
Defense is ready, Judge. I just need to borrow the state's computer so I can
Yes.
Um,
Thank you, Deputy Laura. All right. If there's an issue, does anyone want to use my computer? Ah, there we are.
All right, Judge, ready.
Okay.
Good morning, ladies and gentlemen. Thank you for being with us this whole week. I'm going to talk to you about, or rather summarize the evidence you've heard, witness testimony, and I'm going to do it in 3 specific topics. So let me start off by saying that the state of Texas did not prove the elements of any offenses beyond a reasonable doubt. Okay. The first thing I'm going to talk about is what do we know and what don't we know? Then I'm going to talk about inconsistencies and how those inconsistencies are reasonable doubt. And then the last part, having to do with sympathy or emotions, cannot play a role in your decision today. Okay, so what do we know? Well, we know that Regina Briones poured gasoline on herself. We know that Regina Briones sustained injuries as a result of pouring gasoline on herself. We also know that Regina Briones has lied consistently through the investigation and did so with you guys today. What don't we know? Well, we don't have a lighter. We do not have a lighter. None of the witnesses who testified told you what the lighter, which lighter was used. If they found it, there's just no lighter. We don't know who would have the lighter. We heard testimony that it was Regina, that it was Aaron, that it was Cigarette. We just don't know who had the lighter, if any even existed. We don't know who caused the fire. Again, it went from, it was an accident, to I was smoking, I tripped. I had the lighter. No, he had the lighter. No, we don't know. We don't know. That's reasonable doubt. And again, we don't know if the lighter caused the fire. We don't know. There was nobody here who testified as to whether that lighter caused the fire. Now let's talk about inconsistencies and how those are reasonable doubts. I submit to you that you cannot say beyond the reasonable doubt that on or about the 23rd day of November 2021, Mr. Aaron Trevino intentionally, knowingly, and recklessly caused serious bodily injury to Regina Briones by lighting Regina Briones on fire using a lighter and deadly weapon. And let's see why you just cannot say that beyond the reasonable doubt. So, Kimberly Flores, You guys remember her, she was a lady who came in who was a neighbor, Aaron Trevino. All she told you guys was that she made the 911 phone call. She said the flames were out and the backyard was all wet. And she talked to Sergeant Mendez, and she told Sergeant Mendez, I can't say for sure what happened because I didn't see what happened. That's all we know. Then we had Dr. Chen. He's a gentleman who performed surgery on Regina Briones and knows nothing else about this case. Next, we have Ms. Ruby Samaripa. She's a lady who came in and testified. She's a 911 call operator. Again, she doesn't know anything about this case. We have Dr. Lundy, the gentleman who testified yesterday. Again, he performed surgery on Regina Briones, specifically the hands. He doesn't know anything about this case. The one thing he does know, and I know you guys caught it, is when I asked him if you remember talking to anybody other than Regina's mom. Because remember, during testimony, when Briones said, oh, no, I moved out of the house. And Aaron was taking me to my doctor's appointments. And Dr. Lundy said he does not remember talking to Aaron Trevino. Now we have Sergeant Mendez. Sergeant Mendez told you guys very bluntly, she took no photos of the scene. She took no photos of Aaron Trevino. She did not talk to any of the people in the house. Remember, this is a detective, sergeant, excuse me, who at first meeting found out that there was a dad and a stepbrother. And she was told that it was only Ms. Briones and Aaron. And then she tells you guys yesterday that no one ever told her that there was another male, his wife, and a young child. Okay, she didn't talk to any of them. But remember this, she tried to kind of cover up her story by saying, well, you know, they did mention to me something about a back house, but I didn't really go in there. I said, well, is it in the report? You checked it? She goes, no, I didn't talk to anybody. She was told that Regina went to a barbecue, and the inconsistencies, the lies that Ms. Briones told everybody here, including the jury. One of the things she said was, I initially went to Aaron's house for a barbecue. But Ms. Briones
I'm
told,
gonna object to on this statement.
That'll be overruled. Ladies and gentlemen, you remember the testimony as you heard it.
but Ms. Briones told you guys 2 days ago that she went to return lingerie. And she went to return lingerie and cook pork chops. Sergeant Mendez does not know who picked up Regina. Ms. Briones tells you, oh, Aaron's dad picked me up. But she didn't tell that to Sergeant Mendez. Okay, Sergeant Mendez again was not told about returning the lingerie. She was just told, I went for a party. I went to his house. Again, she also wasn't told that she went to cook for Aaron while returning the lingerie. We also learned about this unknown uncle and unknown cousin. And again, that's very important because remember, this is a lady, Sergeant Mendez, this is a lady who says, oh, I was taking statements and everything in my report is true and accurate, okay? She says, Regina told me that she wasn't cooperating because she had received some very serious threats from an unknown uncle, and an unknown stepdad, excuse me, and a cousin. Well, what are their names? She says, oh, I didn't ask them. Okay, well, did Regina tell your names? No, I didn't ask her. She didn't tell me that. She was told inconsistent stories about the lighter. First, that Regina had it. Then that Aaron had it. No, then Regina had it again. But then Aaron picked it up. They're all inconsistent. That's all we know about. We don't know if a lighter even existed because you guys weren't presented a lighter. She also wasn't told that Regina kept in contact with Aaron Trevino. This is after the hospital. Okay, after the hospital, after she told you guys, I feared for my life. She continued to see him. She didn't tell that to Sergeant Mendez. Also very important is that she was not told that Regina's mom kicked her out, allegedly kicked her out. But remember, 2 days ago, Regina told you guys, yes, my mom kicked me out. And what did I ask Sergeant Mendes? I said, hey, where did you meet with her? Did you ever meet her at a hotel? No, no, no. Did you ever meet her at somebody's grandma's house? I never met her at somebody's grandma's house. Yeah, I always met her either at the hospital or at her mom's house. Everything in her report is true. I bring that up because remember, I asked Sergeant Mendes, everything in his report is accurate? She goes, yes. I said, whatever is in there is exactly what you were told, correct? She goes, yes. I cannot add anything. It's unethical for me to do so. Okay, and I bring that up because remember, in talking to Regina, I asked her several questions and we were going back and forth. And she told me when asking her about her statements to Sergeant Mendes, she said, I never told her that. That's not true. I never said that. But yet Sergeant Mendes wrote it. It's in her report. And Sergeant Mendes told you guys, if it's in my report, because it was told to me. And if it's not in my report, because it wasn't told. Now, Regina Briones. And I want to start off by highlighting February 15, 2021. This is the date where she sat here. Well, not that date, but she sat here 2 days ago and she told you guys. On February 15, 2021, I woke up at the hospital from my coma, and that's when I decided to tell the truth. That's when I decided to tell the truth because I didn't want to deal with this anymore. You guys heard her say that. She sat there and told you guys exactly that line. Okay? But yet after February, and we'll see a little bit, her story was nothing but lies. She told officers she burned herself on accident. She told officers.
Your Honor, I'm gonna argue that's not evidence.
All right, ladies and gentlemen, the jury, remember the evidence as you heard it. You may proceed.
She tells officers she tripped while smoking a cigarette, tripped over a gas can, and that's how she burned herself. She meets with Sergeant Mendes on 3 dates. I'm gonna go over those in a little bit. And again, the inconsistencies, when I asked her on the stand, she said, no, I never said that, I never said that, I never said that. But yet Sergeant Mendes had those questions that I asked her on her report. So March 1st, 2021, March 4th, 2021, May 12th, 2021 are the dates in which Regina met with Sergeant Mendes. And then the last day on that column is her testimony a couple of days ago. March 1st, 2021 is her first visit at the hospital with Sergeant Mendes. And she tells Sergeant Mendes that she went to Aaron's home. No mention of the lingerie, no mention of the pork chop, no mention of the cooking. She says only his dad and stepbrother were present. Not the young lady with the baby or not the president who was married to the young lady. She also doesn't mention anything about this outhouse or back house. She doesn't tell Sergeant Mendes that they had sex. She tells you guys this basically, no, we had sex. Before I decided to end the relationship. He tells her, of course, that she pours gasoline on herself. At that first meeting, remember, this is March 1st, a couple of days after February, where she tells you guys, I decided to tell the truth. She claims Aaron has the lighter, and she doesn't mention anything about stepdad, her cousin, or a TDC, and you have threatened her to not cooperate. The next meeting, March 24th, 2021, at her mom's house, not a hotel, not in Motel 6, not Aaron's grandma's house, but at her mom's house, the lady that she lied to you about and said she kicked me out. The two
I'm
square
trying
foot,
to ask some evidence.
All right, the objection will be overruled.
the two blanks there, I left them intentionally because if you remember from Sergeant Mendes, the only purpose of that meeting was because Sergeant Mendes wanted to find out why did you pour gasoline on yourself? Why did you want to kill yourself? Okay, that's when she tells Sergeant Mendes, I don't want to press charges. doesn't mention the lighter, and again, we don't know. Forgive me, it's not an uncle, it's a stepdad. I don't want to mislead you. We don't know who this unknown stepdad is, or who the unknown cousin are. Or apparently or allegedly threatening her not to cooperate. May 12th, 2021, again, meeting at her mom's house. No hotel, no Motel 6, no meeting at Aaron's grandma's house. She tells Sergeant Mendez, yes, I went to a barbecue at Aaron's house. So now it changes from, I went to his house, oh, I went to a barbecue. Doesn't say who took her, but she does tell Sergeant Mendez that it was only Aaron and her at the house. Dad, cousin, not the stepbrother, not the cousin's wife, and no baby.
Object to the statement of interest.
Overruled.
Doesn't mention they had sex. Now she tells Sergeant Mendez, May 12th, 2021, remember, months after she tells you guys, this is when I'm telling my truth. She says, I poured gasoline on myself, and you know what? I did not want to kill myself. Now she claims she had the life.
Object again, that's not an evidence in the statement of interest.
Overruled.
And again, we don't know who this unknown stepdad or the unknown cousin are because the names are not known. And because Sergeant Mendez doesn't think it's important to ask her who these guys are, without keeping it from cooperating. And then finally, February 15th, 2023, she's here in the courtroom, okay, and she tells you guys, hey, I went to his house to return lingerie. Not to a barbecue, but I went to return lingerie and to make them food. Then we all of a sudden know that it's not just Regina and Aaron at the house, but now we have the dad, the male cousin, his wife, and a child. She mentions to you guys we had sex. She tells you guys, yeah, I poured gasoline on myself. She tells you guys something about a black big lighter. We haven't seen a lighter. There's a very, very important part of the state's elements of lighters, deadly weapon. Nobody found it. We don't even know if it exists. They didn't bring it to you. It's not an evidence. And again, she doesn't tell you about the unknown uncle and the unknown cousin. This is after she tells you guys, I was threatened, lied, I'm a kid, but we don't know the name of the unknown stepdad and the unknown cousin. We don't know it. You know what it is? They don't exist. All right. And finally, ladies and gentlemen, these instructions that the court will give to you guys in a little bit, they're not numbered, but I believe it's page 8, if I kind of quickly. Page 8, there's a paragraph that says, you are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. I say that because you guys are the judges of the credibility of the witnesses. And I have a feeling that in a couple of minutes, the state's gonna come up, and they're gonna get those pictures, and they're just gonna display them all over this courtroom. Look at these pictures. Look at these injuries. Feel bad for her. Feel sorry for her. Playing with your emotions, playing with your sympathy, asking for sympathy, asking you guys to forget about the elements you have to prove, asking you guys to forget about their burden of proof, and say, look, have sympathy for this woman, find this guy. But that's not what we're doing. This law tells you, okay? Beyond the reasonable doubt. The state does not get to move the end zone closer to them by asking for your sympathy and emotions. It's very black and white. Did they meet their elements, every single one of them, beyond a reasonable doubt? And the answer is no. Listen to the inconsistencies. What lies? Who had it? Where is it? You don't know. And even if it was a lighter, did you hear evidence that this alleged lighter caused a fire? Well, we don't know that either. They talk about a cigarette. Did you hear any evidence? Why? We did not. That's the importance of the jury. That's when you guys hold the state accountable and say, look. You guys did not meet your burden. Beyond the reasonable doubt. There's a lot of inconsistencies. It's okay to disagree with each other. It is okay. There's 12 of you guys. Everyone's gonna have different opinions, and that's perfectly fine. If you guys can't agree, that's fine. Let the judge know. If you recall during jury selection, we were asking questions about who was involved in the jury, who had in the jury, and I think there was a juror who said, "Oh, we were involved in the jury." And I believe that juror said, "Oh, yeah, we reached the verdict because it was Friday and we wanted to go home." Don't do that, guys. Don't do that. I know it's Friday already, right? It's early in the morning, but if it gets closer to the end of the day and you guys want to go home, don't. And you're holding on to whatever it is you're holding on and you don't agree, don't just change your opinion because you want to go home. This is a man's life. Okay. So finally, Aaron Trevino is not guilty. Okay. Did the state meet their burden? No. Did the state prove their elements beyond the reasonable doubt? Absolutely not. Can you say beyond the reasonable doubt that Aaron Trevino committed the offense of aggravated assault with a deadly weapon, causing serious bodily injury on a family member or somebody with whom he had been in a relationship? And that answer is no. And because of that, I ask you guys to please find Aaron Trevino not guilty of the offense. Okay?
All right, State, are you ready to proceed?
Yes, sir.
You may proceed.
All right, good morning. This is the first time I've been able to talk to y'all. And I wasn't here for very self. But I think it's common sense that violence has kids. That's exactly what happened in this. Heard this is a quick romance. We met July. He manipulated her, pressured her, moved in with her, that's too long. Immediately began a relationship of control and manipulation. She wasn't allowed to go out anymore. She didn't even see her kids. And then the violence started. You heard her. Police were involved. He hit her. Then he hit her over the head with a bottle. And then you heard from Sergeant Mendez the series of calls that came in. One after another, after another, after another of violence. Right before what culminated in what we saw in the struggle. Now, this is just an intro for your jury deliberation. We'll elect a presiding juror, a woman. You'll look over the evidence. Some things to remember, the police reports, Sergeant Mendez report that was talked about so much. It's not admissible. It's evidence that I should know. It is there for her to refresh her recollection. And there's things that were labeled. There's an incident detail report and the report, they were labeled, they're not evidence. And most importantly, you have to remember what came from the witness. Because what he says is not evidence. His interpretation of what he thinks the testimony was and how he presented it is not evidence. What you heard is the evidence. And what was the evidence? We had the testimony of Ms. Briones. She told you about this quick escalation. About how she just felt controlled by him, even when they weren't together. But yet she didn't want to be any part of it. But yet she did. I showed you the pictures of what she looked like. A beautiful woman. And you said, I'm not gonna show you the pictures and try to come up with your sympathy, but you have the picture before. You know what a tremendous effect that this had on her. And you have the photo of her burnt purse and the contents of what were inside of the purse. You had the testimony of Ms. Kimberly Flores. Bless her heart, she did not want to be here. She said, you have that 911 audio where you can hear the panic. You can hear Regina screaming, help me. Help me. Because she wasn't getting help. She was trying to get help from other people. Because he was not helping her. You have the testimonies of Doctors Chan and Doctors Lundy. And they helped explain what was apparent just from looking at her. The serious bodily injury that she had. She could have died. Dr. Lundy had that conversation with her mother. They didn't know. They didn't know she was gonna make it for a while. And you know, the defense talked a lot. You didn't see the lighter used that day. You didn't see the pictures. They didn't talk to these people on the night of. Guess what? She was in a medically induced coma for 4 months. The police that night thought it was an accident because that's what he told her to say. That's what he said. That's what he told her to say. So there was no investigation into what was really almost the death of Regina by his hand. They didn't investigate it that way. They thought it was an accident. She was in a coma until she woke up. And realized that it's not her fault. He didn't have control of her anymore while she was in the hospital. She was able to say something. And then you had the testimony of Sergeant Mendez. You know, she was really just a gatherer at this point, and she was coming 4 months, 5 months after the fact. You know, she was trying to pick up what she could. You know, she tried to talk to some witnesses, they wouldn't call her back. She met with Regina multiple times. And the thing is, Sergeant Mendez told you, it's common in domestic violence. There is a cycle. And the fact.
Object improper witness testimony, that testimony is not condemned, as Sergeant Mendez was not designated as an expert to testify in that.
All right, ladies and gentlemen, the jury, you'll remember the evidence and the testimony as you received it.
The fact that Regina changed her mind for what was really only 5 days, from March 24th to March 29th, about not wanting to go forward, it didn't stop Sergeant Mendez from looking at the case. Now, she needed her cooperation for pictures, but it didn't stop it. It wasn't a red flag to her, because that's what happens. That's what happens. No assault. So for this case, you have several things. several different findings you have to make. You have to find that there was an assault. You have to find that it resulted in serious bodily injury. You have to find that a deadly weapon, in this case a lighter, was used. You have to find that the defendant and Regina were in a dating relationship. An assault is an intentional, knowing, reckless act that causes bodily injury. So intentionally, you feel that Aaron Trevino had the conscious, objective, or desire to light Regina on fire and cause bodily injury. Or knowing, you know, maybe he didn't say, no, I am going to light her on fire, but he knew, he was reasonably certain that flicking the lighter when she's doused in gasoline would light her on fire. But then also there's reckless. And this covers that circumstance where maybe he's not thinking, I want to light you on fire. That he's, you know, flirting with it. He knows that she's doused in gasoline. He knows that there is an unjustifiable risk that if he flicks that lighter, that she could have serious bodily injury or death. And he did it anyway. He consciously disregarded that risk. And that's reckless. And that's enough. What do we have for the evidence of mental state? Well, we know that defendant was living at the house where the gasoline was stored. We know that the gasoline was stored in a traditional gas can. She told you it was a gas can a couple different times. And she told you that it smelled. There was no doubt it was gasoline. She showed you the gesture she did afterwards. She poured it on herself and she said, then what are you gonna do now? You know, because he had already grabbed her by the ponytail and thrown her on the ground 4 different times. So there's no doubt that he knew she was doused in gasoline. He knew it. And that's the first step. At that point, any action by the defendant in that close proximity with that lighter that caused the flame, it would at the very least meet that reckless, which is all you need. His statement, remember she said he held the lighter and he said, don't think I won't do it. He knew exactly what flicking that lighter would do. And in that moment, he decided to do it. So I submit to you, there is evidence of intentional, but at the very least, reckless. You don't have to agree on this one. Injury required. Serious bodily injury. Injury that creates a substantial risk of death. Dr. Lenny told you that. Injury that leaves serious permanent disfigurement, protracted loss of or impairment of the function of any bodily member or organ. Risk of death, Dr. Lundy covered that. Serious permanent disfigurement. They had to fuse the bones in her right hand together. She had to get a portion of her left index finger amputated. She has scar tissue covering her body. Scar tissue that isn't flexible like normal tissue. Scar tissue that impacts your mobility, that stretches otherwise healthy skin and is painful. You saw her ears were burnt away. In order to find healthy tissue, they had to remove the fat tissue on it. That's why her breasts were gone. They had to look for that healthy tissue. And the way they found it was to go down so deep until it started bleeding. And that's when they knew it was healthy tissue. You saw the pattern scarring from the skin grafting that's going to be there forever. The other, and I don't remember the medical term, but the other circular patterns where the skin grafting didn't take as well. And you know that there's gonna be ongoing procedures, probably for the rest of the life. Protracted loss or impairment of a body organ, she had to relearn how to use her hands, how to feed herself, how to go to the bathroom by herself. She couldn't move her neck because of the scar tissue. She had to have skin from her leg put onto her neck, just so she could move her neck. The next assessment is deadly weapon. The lighter. That's what it was. It was a lighter. She said that throughout. She said, always that it was a lighter. It was his lighter. Don't be confused. Defense counsel kept saying, she said it was her lighter. No, Sergeant Mendes clarified that when I questioned her again. She said she had a lighter. And she had dropped it away. And then when she looked back up, the defendant had his own lighter. It was always his lighter. It was always a lighter. And deadly weapon does mean it can be anything. Anything that would, an innocent item, if you use it in a manner to cause serious bodily injury, it becomes a deadly. Just like the lighter in this case. And also dating relationship, as described by this section of the family code, it's defined in there in the jury charge. A relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. We know they had sex, we know they lived together. We got that. One question I know a lot of you have is why Regina? Why did you douse yourself in gasoline? Why? I don't even think Regina has the answer to that. It was an act of desperation. It was something that she regrets deeply. But it's not what caused her burns. What caused her burns was the defendant. Why did she keep coming back with him? Why did she agree to take the car ride back to his house that day? Why? Why did she have sex with him that day? She wanted to leave. Why did she accept help from his family? Again, I don't think Regina can really even give you a full answer for that. Because it is the ugly, awful reality of domestic violence relationships. It just is. Low self-esteem, shame, embarrassment. She was isolated from her loved ones. She knew he would be there. He might abuse her. But she knew he was going to be there. She couldn't rely on her mom. Her mom would take her, but then kick her out. She didn't really have any friends after this. I don't have all the answers. I do know that if her self-esteem was low enough that she kept getting back with him after he would assault her over and over again, hit her in the bottom, like a head with a bottle. If she kept going back with him because her self-esteem was so low then, think about how it is after the assault. So it may not make sense to us, but sometimes you can't make sense of things when you're put in situations like that. And it doesn't change the fact that he did this to her. Other things to consider, even when she had those 5 days and she decided to go back and not be cooperative, she never said that she was the one that lit herself on fire. That would be the easiest way to drop this case. She never said that. The only other alternative story she said was the day of the incident where she said, allegedly said, I tripped over a gas can and had a cigarette Well, the thing is, she didn't have any burns on her legs. That wouldn't make any sense. She only said that because he told her to. And she never shied away from pouring gasoline on herself, which is an indication she was telling the truth. Because if you're gonna make a lie and want people to believe you, why would you say something like that? It's a statement against your own interests because it's the truth. It's a truth that we may have trouble understanding, but it's the truth. And then Kimberly Flores, she has no interest in this case. She still lives at the house next to his family. Even walking to this courtroom, she was in pain. We had to subpoena her to come here. She didn't want to be here. And when I asked her questions, I didn't ask her, Ms. Flores, what did you hear the defendant say that showed he was guilty? That wasn't my question. My question was, did you hear the defendant say anything? What did she hear? What did she hear him saying over and over again that day? Please don't tell. Please don't tell. Please don't tell. Well, Regina is screaming, help me, help me, help me. He's saying, please don't tell. Please don't tell. That's what someone who is guilty says. That is someone who is more concerned about his own well-being than the woman who he has abused for months, who is literally burning in front of him with her skin falling off. And he's saying, please don't. These are the elements. In Bexar County, Texas, we know we got that. We know Aaron Trevino. We know the date on or about November 23rd, 2020. Did intentionally or knowingly or recklessly, we covered that. Cause serious bodily injury. Of course, serious bodily injury. To Regina Briones by lighting her on fire. And during the commission, used a deadly weapon, to wit, a lighter, which in the manner of its use was capable and did cause serious bodily injury. And Regina Briones was in a dating relationship. Those are the elements. We ask you to use your common sense. When you look at those elements, we went through each one. He's guilty. He's guilty. Now our burden is beyond a reasonable doubt. Not defined in Texas. It is not required that we prove guilt beyond all possible doubt. It's a reasonable doubt. It's a common sense. Use your experience. Use what you know. Standard. There's no definition. That puzzle, we use it in DWIs for every crime. That puzzle, beyond a reasonable doubt, you know that that is a picture of a firearm. Even though there were some pieces missing. And there's some pieces missing in this case. I don't have an answer for you. Regina doesn't have an answer for you as to why she kept going back to him. As to why she put gasoline on herself in that moment. But that doesn't change the fact that we know what happened. We know that he was the one that flicked that lighter. He was the one who knew she was dousing gasoline and still flicked that lighter. And whether in that moment he intentionally wanted her to be lit on fire, or if he simply knew that it was an unjustifiable risk that he disregarded, he flicked that lighter. And thank God Regina is alive today, but her life will never be the same. The state of Texas asks that you find him guilty. Hold him accountable for what he did to her. Thank you.
All right, ladies and gentlemen, you received all the evidence that you're going to receive in this case. I'm going to send you to the back with the deputy for deliberation, and if Sean Leroy and Daryl Rassabelin, if you could remain behind. All right, everyone, please rise for the jurors. Turn off video and audio.
Ghosting on Rihanna did not work. They have been saying
He's back.
on Michael Rihanna. We're gonna play today in 12.
Which I'm sorry.
They sent him up here.
I watched all that.
Ghosting didn't work. That's the 12 company.
Okay, what were you saying?
No, I got it.
Oh, you got it.
Yeah, thank you. Judge, may I be excused to go to the 437?
Yes,
Brittany and normally have my cell phone.
yes,
Thank you, Judge.
you're welcome.
Judge, on the
Yes, what is his issue? So we don't know what the medical issue is? Is it, oh, is it a mental? All right. So who's the defense attorney? Who is the defense attorney?
It's Mr. Jail.
All right, so tell Mr. Bell that he needs to check on him. And we'll reset it, and let's reset for 2 weeks.
Yeah, we can go back to March 9th.
Okay, that's fine.
Okay,
I work over.
I'm gonna have them transferred down there. Normal 15 now.
You need to take your hat off.
Oh, I agree. I agree. I know.
Right. And if you want to call Robert Maurer to have his hearing, if you're here, are you finished with your appointment?
Yes, sir.
All right. If
I
you,
thought you were talking to me. I was like, what, you're across an hour. I was like,
yes,
I don't think I have a summons though. If you want anything else.
sure.
me to text him from here?
All right, and Normie, could you call the attorneys and tell them to come?
Yes, ma'am, that's what I'm doing now.
Yeah.
Right.
Well,
I need it.
no. No, she needs to do that. She hasn't logged in. No.
Well, then that's- See, I can get- It's not a lot.
Did your baby get her seat yesterday?
Yes, she did. So she's excited about it.
Like.
All right, I'll look over it. I'll look over it.
Yeah, no way I can.
Maybe that'll help us.
Yeah, there's no.
Yeah.
My office. I'm like.
File this finish publishing.
I printed it back.
Okay.
Jordan,
Can
deal with it.
I get a copy?
Jordan.
Oh,
Let me get later.
Can we get two copies? Give me one.
Compensation.
Yeah, right when I said it.
All right.
Did you want this, you wanted a copy of mine?
Yes.
And then they're putting a copy to the.
All right, thank you.
Oh, it is, okay. I was gonna.
All right, Ms. Compton, just give us a moment, please.
No problem.
Yeah. Yeah. He was a no, I think but yeah.
All right, Ms. Compton, everyone needs to whisper. Ms. Compton, who's your client?
Judge, it's Brandon DeHoyas. He was the young man yesterday that we did the plea for the motion to adjudicate
All right,
and,
as soon as the deputies bring him out, we'll take up your matter.
okay, thank you.
You're welcome. And they've been asking for us to send these to impact court. So, yeah, so I'll send it there. All right, thank you. David Newman. All right, are you all ready to proceed on the motion to revoke?
No, Judge, we need to confer with the state. This is being handled by Nicole Thornborough, Special Crimes, She's in witness interviews
Yes.
today. I was wondering if we could come back Tuesday.
All right, Ms. Ferguson, can you have this recalled for Tuesday? All right, we'll see you back on Tuesday. Ms. Ferguson will give you the reset form.
Thank you, Judge. Hold on, you guys.
Hey, Mr. Box.
Morning, Judge. How are you?
All right. My understanding that your parents are in town?
Well, they're almost, they were leaving San Marcos at 10, so.
Okay. And is that on Mr. Williams?
Yes, he's present in the courtroom, in the back in the red jacket.
All right, Mr. Williams, you need to make sure he gets rest because he was sleeping in court.
Okay. Well, it wasn't because you're not entertained. Probably because he listened to the state's closing argument.
He has jokes today.
I'm sure.
All right, Mr. Williams, come. Mr. Williams, come forward. All right, why were you sleeping in court today? All right, so here's the thing. There's no sleeping allowed in court. You understand? Don't let that happen again. All right, so he's already been given a plea deadline date.
Yes.
Ms. Ferguson,
Yes, ma'am.
I need a jury trial for Mr. Williams. State, how long you expect this trial to go? It's a felon in possession of a firearm.
I would guess 2, maybe 3 days. Judge.
Okay,
Like I said, I just got on it this.
no, I
week.
understand.
I'm hopeful we're gonna get a resolution.
All right, Ms. Ferguson, what date?
April 3rd.
All right, April 3rd is your plea deadline date and your jury trial date. Mr. Bronk, if you want to come back sooner than that, you're more than welcome to.
We will. Thank you. And I'll be in touch with them. Thank you.
All right, thank you.
Whoever decided to call.
And then, Mr. Mauer, your client is in custody or on bond?
Oh, no, this is.
Custody, yes.
Oh, yes.
All right, so as soon as Deputy Laura is able to bring him out, we'll take that matter up.
And I have a proposed date, and I think the state does as well.
Okay.
If you don't grant my motion.
Okay. Okay, all right, thank you. Oh, and I already have the Hoyas. Thank you.
I would try like. What's his name?
Frank Dixon. Frank Dixon.
Well, yeah.
On Q.
Oh, yeah.
Make yourself original. I mean, how do you do it in a way? It's just gonna be the night for you.
Okay. perfect. All the bullet items were actual story.
Oh, yeah.
Wow.
Hey, Morgan. Yes.
You're gonna start. Yeah, I remember that. You're gonna start pretty soon. Oh, today you lose your rep.
That's right. Yes. Hey, but actually, I brought my calendars. I just. That's Wednesday. Thursday. I just really like the surprised me about knowing that I lost the found the same, which is in my fingers. I'm not going to do this. Of course, I am.
Okay. All right. All right, thank you. All right, is that Brandon De Hoyos? All right, Deputy Lori, if you can have Brandon De Hoyos come down. And then after the De Hoyos, we'll take up your case, Mr. Mauer. Sure. All right, the court is calling 2020 CR 7006 State of Texas versus Brandon De Hoyos. Could I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
For the defense?
Kathy Compton for Mr. De Hoyos.
All right, and are you Mr. De Hoyos?
Ma'am.
Your attorney is by Zoom. Any objections to your attorney appearing by Zoom?
No.
State any objections? All right, so this is a continuation of the hearing from February 16th. So Mr. De Hoyos, I'm going to give you a choice. Because felony drug court does not want you back, and you know why they don't want you back. So your little trips to Crystal City, and you know what that's about. So this is what's going to happen here. I can continue on probation, but you're not doing SAT if you're going to be doing Safe P. And once you get out of Safe P, I'm going to run my little drug court here. And you know what's going to end up happening? Once you're out of Safe P, you're going to report to this court every single day until further notice. So Monday, Tuesday, Wednesday, Thursday, Friday. If it's not a holiday, you're coming in to report.
Yes, ma'am.
Or I can revoke you and you can be sentenced up to 5 years in prison. So which would you prefer?
You said safety?
Yes.
Yes, ma'am.
Here's the thing. Sometimes people you just can't help them because they don't want to help themselves. Have you ever heard of the song Harry Hippie?
No, ma'am.
That's one of my favorite songs by Bobby Womack. You know what some of the lyrics in it are?
No, I do not.
You have this guy named Harry Hippie. Everybody's trying to help him. They try to, and the lyrics go that, they try to help him, his old lady and his children, and they try to help Harry. But you know the thing about Harry Hippie? In the lyrics, it says, how can you help a man who wants to be on the ground? So if you want to be on the ground and won't accept any help and you won't follow through, then there's no help for you. You need to just go to prison and do your time.
Yes, ma'am.
So this will be your help. And I am not going to be considering things like, oh, this is my relative or this is that. That doesn't work in this court. Your relative can be the president of the United States. In this court, everybody's treated the same.
Yes, ma'am.
You could be the most wealthiest person in the world. You could be a billionaire. Doesn't matter in this court. Do you understand?
Yes, ma'am.
So you are going to shape up.
I will. I promise you. I'm tired of living.
Don't do that. Don't make any promises that you have no intention of keeping. You need to show actions. You've been on probation out of this court since 2020. And so far, the only thing you have done is fail miserably. And you fail miserably because you just want to do what you want to do. Maybe you just want to continue to use drugs. I don't know. But you've been behaving as you do, because I know felony drug court is a very good program.
Yes, I was hoping they would take me back.
No, they don't want you back. You failed miserably. And so you're going to have to start doing better. And when somebody gives you tools to help you stop using drugs, your choice is either you use those tools or you do not. Do you understand?
Yes, ma'am.
All right, so this is what the court is going to do. I'll deny the motion. Probation and state are asking the court to deny the motion. Going to alternate amend conditions. You need to take off that hat to include, he's going to go to Safe P and he's to remain in custody until accepted. Upon successful completion of Safe P, he's going to report to the 187 District Court Monday through Friday until further notice. He's going to be on a GPS upon release. And he is not to leave Bear County. And of
Judge,
course, that not leaving Bear County is after Safe P, because I know Safe P is not in Bear County. Yes, counsel?
I'm sorry, Judge. I didn't mean to interrupt, but I did want to ask you if you could just clarify for the GPS that the fees for the GPS would be waived, because those are very pricey and he is at this point indigent and probably will be for a little bit at least while he gets his feet back under him when he gets out of safety.
All right, I'll ask that fees be waived or deferred. And he's going to have employment within 30 days of release from custody. No employment as a home health care provider with minors. And he's going to do the UA hotline until further notice. And probation, I'm going to want field visits upon release 2 times per month until further notice.
Your Honor, would the court consider waiving his requirement to report daily to the courtroom once he provides the court with verification of an employment of a job that he
No.
has. Okay,
No, because if he was in felony drug court, he would be reporting daily.
I'll report on Thursdays.
Well, you're reporting daily in this court because then obviously that didn't work for you.
100%.
How old are you?
29.
So you're 29 years old. So you are going to be in this court every single day. If you miss reporting to this court Monday, Tuesday, Wednesday, Thursday, or Friday, a motion to revoke is going to be filed.
That's fine.
If you leave Bear County, even if you just dipped your toe across a different county line, a motion to revoke is going to be filed. You understand?
Yes, ma'am.
so Judge, I'm sorry, I just want to clarify for him, so there's no question. Does he need to report at a certain time each day, or will
9
he have
a.m.
a window? Okay,
9 a.m.
So ma'am, if I get a job, I have to let them know I have to report every day.
9 a.m.
9 a.m.
Is there anything else?
Do you know which CP I'll be going to?
No, I do not. But I do know you would not be going to safety if you would have done what you were supposed to do. You would have been in felony drug court, maybe successfully completing it. I know that when I placed you on probation in 2020, you probably would have been done, but a motion to revoke was filed. So then you got sent to safety in 2021. That's,
I went Saturday.
no, you're going to safety.
Oh, I thought you said I was sent to.
No. Anything else?
No, ma'am.
All right, and there's to be absolutely no Crystal City for him. So nobody come to me with a motion asking if he can visit relatives in Crystal City.
So my
That's
son
no.
goes.
No, you're not going there. I know what issues have been occurring in Crystal City, so you're not allowed to go there. And do not play games to me and pretend like you don't know. You are not allowed to go to Crystal City. You're not allowed to leave Bear County. Do you understand?
Yes, ma'am.
All right, is there anything else?
Nothing further to have a seat on.
Anything else?
You know how many
no, Your
days-
Honor, thank you.
How many months I'll be defending?
You really don't want safety. See, this is what ends up happening. Everybody comes before me sometimes when they have a drug issue and they're not ready to address it. What ends up happening is they try to write their own program. I'm going to tell you this. You're going to wait for your transfer to safety. Safety is a 6-month to 9-month program. Then when you get out, you're going to have 3 months of aftercare.
Yes, ma'am. That's fine.
Anything else? Any other questions?
No, ma'am.
All right, you can always choose to go to prison for 5 years. It's completely up to you.
That's fine.
Anything else? Counsel, anything else?
No, Your Honor, thank you. Can I be excused?
Yes, you may be excused.
Thank you for letting me zoom in. I appreciate it.
Oh, you're welcome.
Have a good weekend.
All right, you too.
Bye-bye.
Bye-bye. Are we ready on Mr. Gooseman?
I'm ready.
Okay,
You want us at the bench?
sure. And Mr. Gooseman, if you could come up, please. And the motions you have, it's only on the, we're just here. Okay.
The ag assault, the one ag assault is kind of carried with it. The victim on the ag assault is the witness on the murder case.
So then the case that the court is going to call is just going to be the murder case.
This one.
Court is calling 2019 CR 10921, State of Texas versus Brandon Guzman. Could I have parties announced for the record for the state
Jason Jorgens for the state.
defense?
Robert Maurer for defendant, Your Honor.
And are you Mr. Guzman?
Yes, ma'am.
All right, the first thing, the defense has 2 motions, motion for speedy trial and the application for writ of habeas corpus seeking release because of delay. State, have you had a chance to review both motions?
Yes, Your Honor. And just to be clear, the motion for speedy trial, was that dated back in September of last year? That's the most.
No, one was, another one was e-filed, but it wasn't e-filed till yesterday, unfortunately. So it just came through. If I got my copy, you're gonna have my copy. Here you go.
Thank you.
Okay, Judge, we're ready.
All right, so we'll proceed first with the motion for speedy trial. Defense, it's your motion. Everyone in the box, excuse me, in the box, I'm either gonna need you to move down to the end or whisper. Oh, no problem. All right, defense, it's your motion.
Judge, we filed a speedy trial motion on this case due to what I feel is excessive delay. My client's been incarcerated since 2019. This previous Tuesday was the 14th trial setting. There's been no motions for continuance filed by the defense ever on this case. I pulled the record of all the settings. The only motion for continuance was filed by the state back in, well, there was one in 2021, was a state's motion for continuance based upon discovery issues. And the discovery issue, if the court recalls, was an issue about the state saying that there was cell phone mapping data that had been sent off to the FBI that my expert needed to review in order to make a determination whether or not the evidence the state was alleging about location tracking was valid. So unfortunately, it turned out that we came back in 2022, and this is, I think, the September 27th, 2022, and Ryan Grimmer, who was the first chair at that time, informed myself in the court that in fact the cell phone mapping data had not been sent off, and there was an agreement that there would be no attempt to use any cell phone mapping or tracking evidence. So there was over a year's worth of delay while we were waiting for evidence that had never been submitted to the FBI and is not being made part of the trial. So my client, of course, we had a previous speedy trial motion. We had requested bond reduction before, and I understand the court's concern about the nature of the offense.
Well, with regards to the bond reduction, we'll address that in.
I understand. My entire point is the cause for the delay on this case has not been the defense. The cause for the delay on this case for over a year was the state not providing evidence and then turning out the evidence was not actually submitted. And so my client is, and I understand the issues with COVID, and we all dealt with the Zoom hearings and things like that. But even after COVID, we've had delay based upon evidence that was not submitted or evidence that was not, I wouldn't say turned over, because it turned out the state didn't have the evidence either and was never requested. So my client suffered through an extra year of incarceration based upon procedural issues with the DA's office. And it's unfair to him that he should be stuck sitting in jail all this time based upon issues with discovery within the DA's office. Like I said, this is a 14th trial setting when we were here on Tuesday. The defense, other than when we were waiting for the discovery, has been ready. And I've been ready on every other setting. But every time we show up, another case goes. Even cases like this week, the case that went to trial was a defendant who had half the time of incarceration that my client did. I announced ready for trial, and I have been ready for trial other than waiting for the FBI mapping data ever since. So I'd ask the court to dismiss the case based upon lack of speedy trial. I don't think the way that my client has been treated procedurally is fair to him. He's been incarcerated for almost 4 years, and I think the case should be dismissed or called to trial right away.
All right, state.
Your Honor, for the court's consideration, I have the case of Dragoo versus State. It's 96 Southwest 3rd 308. I previously tendered a copy of this case to the defense. In that case, Your Honor, there was a similar delay of about 3.5 years. And that the court in that case analyzed the normal Barker factors in considering the motion to dismiss for lack of speedy trial. with regards to the first market factor, the length of the delay, obviously there has been more than the presumptive 8-month window for this case. So because of that, we're moving on to the remaining 3 factors in the analysis. For the reason for the delay, Judge, the second Barker factor, the mere passage of time under United States versus Spoonhunter, mere passage of time itself does not constitute a denial of the right to a speedy trial. In this case, and most significantly, there was no bad faith or no intention by the state to deny the defendant his right to a speedy trial. The state has only requested in the entire duration of this case, the state has requested 1 continuance, as opposing counsel mentioned, for a discovery issue that came up. And also, as opposing counsel mentioned, there was a pandemic, right? We have a once in a lifetime event that occurred during the pendency of this case, during which time the courts and the courthouse were shut down for going on a year, close to 2 years at some point, during which time a trial just would not have been possible because there were no jurors being brought in to figure cases. In regards to the third Barker factor, the assertion of the right to a speedy trial, the defense, as far as I can tell from the record, first moved for a right to. I believe the arrest in this case was July 29th of 2019. I believe the first assertion of a speedy trial was in June 11th of 2021. And of course, that was during the middle of the pandemic where a speedy trial could not have been granted because jurors were not being brought into the courthouse. With regards to the with regards to the, I don't believe defense has articulated any specific prejudice other than the length of the delay in this case. But at the very least, that would weigh against the defendant for not articulating particularized prejudice. We believe that the assertion of the right to a speedy trial also weighs against the defendant because he did wait so long before first asserting his right, and also his lack of persistence in asserting his right to a speedy trial. The next assertion of his right, I believe, was about a year, a little less than a year after his first assertion. And in Dragoo, the court did note that, sorry, I don't know, let's find it. Did indicate that the lack of a timely demand for a speedy trial indicates that he did not really want a speedy trial, and also furthermore that he was not prejudiced by the lack of one. The inaction of the defense weighs against the delay being a violation of a right to a speedy trial. To distinguish Dragoo from this case, Your Honor, in Dragoo, there was no reason offered by the state for the delay, which the court held does not indicate or does not significantly weigh against the state. In this case, we do have a reason for the delay, Your Honor. Again, we had a 2-year pandemic that essentially backlogged the entire system. So we have a reason for the delay, which I believe would indicate that factor should not weigh for or against either party. As a result, and just to address defense counsel's last point, I don't believe he raised in this motion, but in moving to dismiss the case for lack of speedy trial, there is case law that indicates that an assertion that a case should be dismissed weighs less heavily against the state, in that the defendant does not actually seem to want a speedy trial, and he seems to want his case dismissed. So for those reasons, Your Honor, we're asking the court to deny the motion and to deny the motion to dismiss for lack of a speedy trial.
May I respond?
Yes.
So, Judge, as far as the issue about assertion of a right to speedy trial, we did it during the middle of the pandemic. Then if I'd like the court to take notice of the state's motion for continuance that was filed for discovery issues. And that was when the issue was raised about cell phone mapping data
And
that had not been turned over to me. That was back in
June 14th, 2021.
That was my motion. That was my speedy trial motion, correct?
No, that was the state's motion for continuance.
Yeah, okay, that's correct. And then September 27th of 2022, we had a hearing in which Mr. Groomer informed the court and informed myself that in fact, the cell phone mapping data had never been sent off to the FBI. So the evidence that I had been waiting on, that I was supposed to rely on for my trial, that I had an expert prepared to review, never existed in the first place. So if your court note looks at the timeline, we're talking about 13 months roughly, where we were waiting for data that the state said they had, that they were going to get to me, that never existed. And of course, had we known that at the time, we could have tried the case back then. As far as any sort of harm to my client, I apologize for not articulating the fact that he's been in jail for now 1,292 days. I think that would articulate his harm. The fact that he's been held in jail all this time, particularly when over a year of that delay is based upon error in the DA's office as far as evidence that was supposed to be turned over. So, and if the state's argument is, during the pandemic, I understand that, but subsequent to the pandemic, when the courts opened back up, we had a large period of delay waiting for evidence that the state said they had, that they were going to get to me, that never existed. And then I've been ready for trial every single time since then. I'm ready for trial now. I was ready for trial on Tuesday. The entire issue is we keep coming to court for trial, and other cases keep going, even cases that are not as old as my client. So there's no attempt to avoid trial. I've been ready, but I think based upon the undue delay, my client's entitled to a dismissal.
And Judge, if I could very briefly respond, because you brought up a point that is actually covered by Dragoo.
Yes.
In Dragoo, the defendant failed to assert he claims that he failed to assert his right to a speedy trial because he was waiting on a dismissal by the state, or essentially the state had apparently promised to dismiss the case at issue in Dragoo if there was a final conviction in a separate case that the defendant was charged with. And they're asserting that that was the reason for the lack of assertion of the speedy trial right. We've got a similar situation here in which the defense is saying that they're not asserting the right to a speedy trial because they were waiting on discovery. The court did not find that persuasive in Dragoo. So the reliance, if there was any, was in the court's view, the appellant quietly acquiescing to the delay.
Judge, I'd like to respond to that.
Just 1 second. Isn't it slightly different than the defense waiting for a dismissal as opposed to the defense that's waiting for discovery that may or may not be exculpatory?
Sure, yes, it is different, Judge. I was just pointing out that it was analogous if they're waiting on something from the state. They still have an obligation to assert the right to a speedy trial if that's what they're seeking.
But they were waiting on discovery, my understanding, and I remember distinctly, they were waiting on discovery from the FBI with regards to some sort of GPS mapping. And I remember, I think the waiting or the request for discovery started with ADA Nesbitt.
Correct.
And then it went to ADA Groomer.
Correct.
And counsel, just to address your issue of other cases going before him. Some of the cases that went to jury trial before him was because they were already set for trial because we were waiting on this mapping thing. And Mr. Guzman, I want you to understand when there are other cases that may not be as old as yours and they're going before you, it's because everybody knew that they were set on this specific date. So some of them already had their setting while we were waiting on this FBI mapping.
If I can respond, so subsequent to us being informed back in September of last year that there in fact was no cell phone mapping data, we've had several settings we've been ready on. And to say waiting on a dismissal is the same thing as saying waiting on evidence that may be exculpatory, I think is a nonsensical argument. I can't proceed on a case if I'm told there is cell phone mapping data that the state intends to rely upon at trial that may prove either, could prove exculpatory, then of course, I've got to wait for it. I've got to see what's there. So that delay took, if you look at the calendar from the time the motion for continuance by the state was filed to the time we had the hearing where Mr. Groomer informed us there was no mapping data, was over a year. So that shouldn't, to say that I should have argued for a speedy trial because the state hadn't provided evidence, I don't think makes any sense and doesn't track to the argument from the Dragon case at all. The state was in control of the evidence. I had to wait for the evidence to make sure that I protected my client's rights. And then once the state informed us there wasn't any evidence, then I was ready for trial. And so the delay or to argue that I should have filed a speedy trial motion while I was waiting for, evidence that was potentially exculpatory, I don't think bears any merit.
Okay. All right, so with regards to the motion to dismiss for speedy trial, that will be denied. What I am going to do is place this on the docket, and regardless of whatever is set, this will be the case that will go. So have both parties had a chance to confer on a date?
I think we have dueling dates.
All right, so what date are you requesting, defense?
I'm requesting March 20th, or I'm sorry, March 21st, because your dockets are Tuesdays, right?
Yes. And let me see. You're requesting March 21st,
21st.
and state, what are you requesting?
Judge, we're asking for April 3rd. If the court isn't inclined to reset it that far, we'd ask for March 27th.
All right, and I'm assuming the reason why the state is asking for the week of March 27th is because that's criminal trial divisions week.
Sorry,
Jason.
Yes, Your Honor.
All right, so family violence is the week of the 27th.
And I'm in Lee County on the 28th. In district court. That's what I asked to do the 21st.
So we would ask for April 3rd then.
All right,
Friday's
so
Good Friday.
that's true. So here's my question. The week of March 20th, is a murder case already set on that day or something else that's set? All right, so a murder is already set for that week. Mr. Maurer.
Is it older than this case?
Yeah. You're trying to see, right?
I want to go.
No. Here's the thing, Mr. Guzman, I don't want to bring you back on March 21st if there's a murder case that is definitely going to go that day. And so all the trials that are set, we have several murders that are set that day. So if we move it to the week of April 3rd, we will definitely be going the week of April 3rd. So it would.
I guess my concern is with Friday being Good Friday.
We can do jury, what we can do is we can do jury selection, and jury selection would happen on April 4th. And then everyone can start their testimony. And then I can have the jury come back that Monday. So the fact that it's Good Friday is not going to be a problem. And when we awarded a jury, we can just see who's going to be out of town, and you all can take that in consideration in selection.
I would still request the earliest court date possible.
All right.
Just based on the amount of delay on this case.
All right. So Mr. Maurer, I understand what you're saying, but I'm going to move it to April 3rd will be the day that you all will come in to make sure that if there are any other motions that need to be heard. But Mr. Guzman, your actual jury trial and jury selection will happen on April 4th. And Ms. Ferguson, because that is the week of Good Friday, can you make sure that we've already put our notice in that we're going to need jurors here on April 4th?
Judge, the jurors are going to be downstairs from now on.
Yes.
So we can.
Well, but still, I understand, but make sure that there are jurors there on April 4th. That's what I want to make sure. I understand that they're doing this thing where we can order jurors whenever, but sometimes that doesn't happen. Tell them that the 187th needs a panel on April 4th. I don't want us to not have a panel available to us.
I will contact them right now, Judge.
All right, thank you. So we're going to make sure that we have a panel.
Okay, Judge, the other issue I wanted to raise was bond. My
Yes.
client's been incarcerated.
We're going to get to that. Let's do this first so that everybody know where we are. So you're going to be brought over on April 3rd. On April 3rd, any motions that anyone has that needs to be heard, we'll hear it on that day. Are there any other motions? I'm assuming there's no motion to suppress or anything because those are usually carried with. You won't be brought over dressed for trial on that day. It's just to make sure that everyone has everything that they need. Then you'll need, on April 4th, you'll be brought over dressed for trial. You'll be dressed for trial in whatever clothing, civilian clothing you have at the Bexar County Jail. If it's something else that you'd rather be attired in, you'll need to speak to your attorney and they'll need to do a clothing exchange and you'll have to sign documents for the clothing exchange. Counsel, if there's an issue with clothing exchange, please let us know on April 3rd, make sure that that happens. All right, so the next issue we have, and
Sorry, Judge, just for clarification, we're starting testimony on the 5th then, right?
yes,
Okay. Thanks, Judge.
you're welcome. So let me put this on the calendar. So because of all the issues, and I already know that you want a trial, but I'll make April 3rd the plea deadline date and the jury trial date, just because of all the issues that we've been having. All right, so then the next issue we need to take up is this bond issue defense has filed. Have you all had a chance to review the application for a writ?
Yes, Your Honor.
All right, State, are you ready to proceed?
Yes, Your Honor.
All right, defense.
Judge, my request is that my client be granted a PR bond. I know it's unusual on these cases, but based upon the extreme amount of length of incarceration, I think it would be appropriate to grant him a PR bond. The court can set full house arrest with GPS. I just think he should be entitled to that. There's been an extensive delay on this case. And I think, in all fairness, I think he should be granted a PR bond.
All right,
If not, I'd ask the court to reduce the bond to the lowest amount possible.
all right, the PR bond will be denied. State and defense, have you all had a chance to discuss with regards to a bond reduction?
I haven't heard.
I just think that I doubt we'll come to an agreement because
If you all will confer to see if you all can come to an agreement on a bond reduction. If you can't come to an agreement, of course, I will set a bond.
Okay.
But just talk to each other.
Okay, and briefly, what on the hearing we have with Ryan Rumor concerning the cell phone mapping data, the court made an order at that time excluding mention of cell phone location and tracking evidence.
Yes.
So I'd like to see if I can get a copy of that just to make sure it's on the record. So we can raise it on motions in limine or put it on motions in limine at the time of trial.
It should be on the record, but that will be with Brenna DeMoss. And I believe that was something that was requested by the defense because the state had data that was supposedly sent to the FBI. But then my understanding is that no one sent it to the FBI. So there will not be mention of cell phone mapping data because there is no cell phone mapping data.
And Judge, I think the court actually excluded all mentions of any location tracking or anything else because without the mapping data, cell phone location evidence is irrelevant. So that should be part of the hearing. And I think Ryan conceded to that. So I'd like to see if we can get a copy of the transcript just to make sure we're specific as far as what the state conceded to. I don't know how to go about where I'm.
Well, we'll contact Ms. DeMoss, but as far as the courts is concerned, there is no mapping data. Correct, State?
Sure, Judge.
I mean,
As far as I know.
Sorry, the states where there's no mapping data.
so then there is no pinging of towers testimony that is going to be before the jury. I think that would be unfair to the defense because they've been waiting for mapping data and none has been forthcoming. But we can, I think the state understands the court's ruling,
Yes,
but counsel, if you still would like to find the, we can get in touch with the former court reporter, Mr. Moss, and find the exact.
I'd like to just because I think that specific conversation was it was going to preclude any detectives or any witnesses for the state from mentioning location tracking or location cell phone evidence. Because with that, that was the entire issue with that my expert said without mapping data, it's irrelevant. And I don't want, and we talked about not making sure nobody got up there and said, well, we have tracking stuff on cell phones, since in fact, there is no evidence to corroborate it.
All right, state.
Judge, I guess I don't know what the specifics of the agreement were with the prior prosecutors. We don't intend to get into the cell phone mapping data unless the defense somehow opens the door to it.
All right, and no issue that there was any type of tracking?
The only thing I can think of, Judge, and I don't know whether cell phone extraction exists for this case, but if there was a cell phone extraction, the cell phone may have location data of places that he has visited, which wouldn't be a mapping issue, it would have the coordinates that the extractor could testify to.
That's the exact issue that my expert talked about, because without the mapping data, though that evidence is irrelevant. And so that was the entire issue that we raised on that hearing.
All right, this is what we'll do.
That's not a cell phone.
This is what we're gonna do, because the whole issue of this is what the previous prosecutor agreed to, and based upon that agreement, what the court ordered. So we will get in touch with court reporter DeMoss and have her pull the record on the issue of tracking and mapping data and state if that is what the previous prosecutor agreed to in the court order, then that's what's going to be agreed to in order.
Sure, yeah.
So we'll have her pull that.
All right, thank you, Judge.
Is there anything else? You are going to
We'll talk.
confirm? Okay, thank you.
Sorry. Judge, I think you'll probably just need to make your own decision on the bond amount. I think we're. Judge.
Oh, okay, then come back forward.
My second chair.
Okay. All right, we're back on the record on Guzman. Defense, what bond amount are you requesting? The court has denied your application or your request for a PR bond.
Judge, I request a $25,000 bond.
All right, state, what are you requesting?
We're requesting the current bond. I think there's currently a $125,000 bond.
Yes.
We're requesting the court to keep that in place in consideration, not only of the nature of this offense, but also the fact that Mr. Guzman is charged with, I believe, 6 felony cases from 4 different states. And four of those charges are violent offenses, aggravated assault or the murder that we did today.
All right, and what are those cases and what are the dates?
The cases are 2019 CR 11945, which is an aggravated assault with a deadly weapon from May 26th of 2019. Then 2019 CR 11418, which is an aggravated assault with a deadly weapon from June 24th of 2019. And then from the day of the murder, he is also charged with aggravated assault with a deadly weapon. That's July 29th of 2019 in cause number 2019 CR 10922. And then subsequent to the murder, we had a case of felon in possession of a firearm, as well as possession of a controlled substance, penalty group 1 to 4 grams, from July 30th, 2019, the day after the murder. And that was in cause numbers 2019 CR 11419 and 11420.
All right, and it's your motion, so I'll give you final.
Judge, I understand the issue with the other cases. I still think based upon the issues we've been dealing with, a $25,000 bond is appropriate with whatever conditions the court feels is appropriate. And I'd ask the court, I should have had my office file the same motion on the ag assault out of the same transaction to set the same bond amount.
All right, and which aggravated assault is that?
The last one that Jason read, the one from July 29th, 2019.
And what's it cause number?
It's 2019 CR 10922.
All right, any objection to the defense's oral motion to reduced bond on 2019 CR 10922.
Yes, we object to that bond reduction for the same reasons, Judge.
All right, no, do you have any objection to counsel presenting that motion orally?
Oh, no, that's fine.
Okay, but you're rejecting to his oral motion for the same reasons?
Yes, Judge.
Okay. All right, the court will deny the motion for bond reduction. You will be here on April 3rd, and your case will go for jury trial on April 4th.
Thank you, Judge.
All right, thank you. Who's here on Juan Pablo Avalos? All right, and have you conferred with the state on a jury trial date?
Just haven't, but we go ahead and do that. I we're just. So.
All right.
28th or.
All right, if you can confer with the state on that, because I know they have a lot of first degree felony cases. So if you can confer and then see if Ms. Ferguson is okay with that date.
I'm sure we'll just think.
Yes. Who's here on Philip Diller?
Alex Sharp, Judge.
All right, Mr. Diller, come forward. And your client is requesting jury trial?
Yes, Your Honor.
All right, is this criminal trial division or family violence?
Family violence.
All right, Mr. Diller, thank you for always dressing appropriately for court. All right, state, we are going to have you confer with the state.
We-
Confer Ms. Ferguson, you have a date?
Oh, as far as dates?
Yes. All right, if you-
I'll try to fit in whatever you tell me the next day.
No, if you'll confer with
Brittany.
probation, and then probation can see if we can fit you in on the docket for
Okay.
whatever jury trial you all have agreed upon.
Okay,
All right, thank you.
thank you, Judge.
All right, could you have the defense attorney come back? Good morning. Oh, no, you can leave them here. Yes. Who is it? Oh, Diller is, he's scheduled for jury trial. Philip Diller? Oh, no.
There's a conferred on a date. I need to report to you at the moment.
You need to ask Ms. Ferguson to see if it can actually be fitted on that docket at that day. And then if it can, then report to me.
Yes, ma'am. Thank you.
Sure. But Deputy Laura, we'll need Mr. Trevino out. Okay, thank you. Oh, you two have a good one. Good seeing you. How you doing? Oh, awesome. So are you still being sent to different counties? Well, that's fun. You get to enjoy the scenery, right? There's one attorney, it was, what was his name? He's since passed. It will come to me, but I remember he used to visit every courthouse in the county and take photos and send them back. Rubio. Yeah, he used to do that all the time.
It's interesting to see how each county operates differently.
Oh, it is.
Just how judges are turning out procedures.
I always say there's so many personalities to deal with, right? Yes, on Avalos.
Yes.
Norman, can I see the file on one Avalos, please? I think, let me see if I have it still. I do.
We
Yeah.
think that April the 11th is a good day.
All right, Mr. Avalos. Your jury trial date is going to be April 11th. And I believe that should be a Tuesday. All right, so if there is some other motions that the court needs to hear, then you'll need to set that and come in the day before and have us hear that. All right, is there anything else? Thanks for dressing appropriately for court. You always dress appropriately. I appreciate that. All right, they'll give you a reset form.
I have Jonathan Crow on the docket, your honor. It's a recall from yesterday. You should have the file there.
Yes, where's Jonathan Correll?
He's sitting back here. Would you like me to bring him up?
Yes.
I'm sorry, Judge. I didn't know he'd stepped up.
All right, so what are we here for?
Judge, we just need a reset. The state gave us some discovery on a motion that we had filed last time we were here. I need to send this to our expert. And I know just from my brief scanning through it that there is some things missing, but I'd rather her look at it and tell me what exactly it is that she needs so that the state can work on getting that. They've been helping us out with the lab, going back and forth.
Ms. Ferguson, I need a 30-day reset on Crowell. And have Mr. Crowell come in.
Yes, Judge, she's I think we had ran to the restroom, but I'll have to.
And Mr. Cabanas. If you'll share that with
Yes, Your Honor.
the state. All right, so what date, Ms. Ferguson? All right, we're gonna come back on March 27th, and that's just to make sure that everyone has their discovery. Thanks for dressing appropriately for court. After you get the reset form, you're excused.
Thank you, Your Honor.
You're welcome. Who is on Villamil? And Mr. Villamil, come down. All right, where are we on this case?
Your Honor, it's pretty early. I actually don't have the file yet from the intake, and so I have not been able to get him an offer or to make sure that discovery is complete.
All right, Ms. Ferguson on Villamil, can I have a 45-day reset, please, for discovery?
We can do March. Let's do April 6th.
All right, so we'll come back on April 6th. Counsel, if you have all the discovery and you want to come back before then, your attorney is more than welcome to ask to come back before then. All right, is there anything else?
No, Judge, thank you.
All right, thank you. All right, so you all have, we're not on the record, so you all have seen the question.
Yes.
Number one, I don't know who her is, right?
Yeah.
Number two, what I'm suggesting is the supplemental charge. I have received your note. Under the law, I cannot read testimony back to you generally. You must have a dispute about the testimony that you're asking about, and you will need to specify exactly what you are in dispute about. If the jury specifies as to what they are in disagreement about with regard to the statement of any witness, then they may, upon application to the court, have read to them from the court reporter's notes, just that part of such witness testimony or the particular point in dispute and no other. Are you all okay with that?
I'm okay with that. Yeah, I think that's in the jury instruction, isn't it?
It is, but people don't. All right, so could I have Mr. Trevino out? Okay, no problem. And Brittany, if I can forward this to you. Okay. So you can print it out for me, please. Yes. Yes.
He's here, Your Honor.
All right, thank you.
Oh.
Your Honor.
Yeah.
Mr. Diller's case, May 9th.
All right, Mr. Diller, if you can come forward. All right, Mr. Diller, your jury trial date is going to be May 9th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to appear. Otherwise, you have to plead open to the court. Do you understand? All right, thank you. Thank you for dressing appropriately for court. Ms. Ferguson will give you a reset form. Thank you.
Have a wonderful week.
Oh, thank you. You too. Thank you. All right, if everyone could please clear the well of the courtroom, and if everyone could please whisper. We're going to go on the record in 2021 CR 7554, State of Texas versus Aaron Trevino. Can I have parties announced for the state
Brittany Mitchell for the state.
and defense?
Alfonso Cabañas for the defendant, Your Honor.
And are you Mr. Trevino?
Yes, ma'am.
All right, the court has received a question from the jurors. The question is, can we get a portion of her testimony or her full testimony? State and defense, have you had a chance to review the jury question?
Yes, Your Honor.
Yes, Your Honor, we have.
The court proposes the following supplemental charge. Members of the jury, I have received your note. Under the law, I cannot read testimony back to you generally. You must have a dispute about the testimony that you are asking about, and you will need to specify exactly what you are in dispute about. If the jury specifies as to what they are in disagreement about with regard to the statement of any witness, then they may, upon application to the court, have read to them from the court reporter's notes just that part of such witness testimony or the particular point in dispute and no other. Any objections, state?
No objection.
Defense?
None from defense counsel, Judge.
Is there a request to have the jury brought in to have this read to them, or is it, are there any objections to having this supplemental charge just sent back? Any
No
objections to have
from
it sent back?
defense To being sent back, Your Honor.
No objection.
All right, thank you.
Thank you, Judge.
Oh, and Dinah? Yes, yes. You're welcome. Hi. Oh. Christian Segovia?
Would you like Mr. Segovia?
Yes. All right, what is happening on this case?
So Judge, we've conferred with the state. They have tendered an offer. They would also like to speak to their victims, which may impact the offer. And so we're asking for a short reset for a plea deadline. That should do it for us.
All right, how much time are you requesting?
I don't know, a couple of weeks.
Couple weeks, Judge, we have reached out through text and phone call, just so far as we have.
All right, Ms. Ferguson, I need a 2-week reset on Segovia, please.
March 2nd would be much better.
All right, so we'll see you back on March 2nd.
Thank you.
All right, who's here for Jesus? Realme? All right, thank you, Mr. Young. Thank you. Don't fall. Who's here on AJ Delgado? And where is Mr. Delgado? Mr. Delgado, come down, please. All right, and what is the charge on the last one? Sorry. All right, thank you. All right, so Caroline has just informed me that he has another case that he was recently indicted on. So it appears that we need to have this reset.
Well, it's a 701 case, Your Honor. And the other case is criminal trial, so we'd be dealing with aggravated, obviously.
All right, so what I'm going to do, because the other case has just been indicted on, I'm going to give them, Mr. Delgado, a 45-day reset. That way everyone will make sure that they have the discovery when they come back. You understand?
Yes, sir.
You have any questions about anything, Mr. Delgado? All right, Ms. Ferguson, I need a 45-day reset on Mr. Delgado. And can you make sure the other case is set on the same day as well? Thank you. Thank you. Parties on Roland Davis.
Ready to proceed, Your Honor.
Okay. And is this a motion to revoke?
It is, Your Honor.
Court is calling 2020 CR 10708, State of Texas versus Roland Davis. If I can have parties announced for the record for the state.
Debbie Cruz on behalf of the state, Your Honor.
Defense.
Andrew Hicks on behalf of the defense.
And are you Mr. Davis?
Yes, Your Honor.
All right, my understanding, counsel, is you were appointed today, is that correct?
That is correct, Your Honor.
All right, do you need more time to prepare?
No, Your Honor, I believe we're ready to proceed today.
All right, and Mr. Davis, you understand that this attorney has a specific amount of time to prepare, namely 10 days to prepare for a hearing on this matter. Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to continue?
Yes, Your Honor.
All right, I'm going to show you what's entitled Motion to Adjudication of Guilt and Revoke Community Supervision. You review that with your attorney, you understand it?
Yes, Your Honor.
Are you the same Roland Davis who was placed on deferred adjudication in 2020 CR 10708 for the offense of aggravated assault with a deadly weapon on April 11, 2022, for a period of 5 years. Is that you?
Yes, Your Honor.
State?
Yes, Your Honor. On or about the seventh day of October, twenty twenty-two, in Bear County, Texas, the defendant Roland Davis did then and there illegally use a controlled substance, namely methamphetamine, in a violation of condition number 2.
How do you plead to that? True or not true?
True.
State?
Your Honor, we'll be waiving the rest of the allegations alleged.
Any objection?
No objections, Your Honor.
Mr. Davis, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there an agreement?
There is, Your Honor.
What are you requesting?
We ask that the motion to adjudicate be denied, Your Honor, and that if the further adjudication be amended to reflect and add a partial GPS for 90 days, work purposes only, monthly drug tests, MRT, and that the defendant be evaluated for DBRF.
All right. And defense, are you in agreement with that?
We are in agreement with that, Your Honor. If we could just ask the court for any of the GPS fees to be possibly deferred. Mr. Davis is going to be working pretty soon, and until he gets back on his feet, this would certainly help him out.
Why is there a request for DDRF?
Your Honor, it's based on the evaluation.
Okay, and so how are we addressing the issue of the positive meth?
Your Honor, it was a lapse in the judgment at a get together that he attended back in October of last year. It's something he certainly regrets and something that certainly will not be happening again, and especially in light of the monthly drug tests that will be continuing. This entire ordeal has cost my client, his kids right now are currently in foster care. He's a single father. He's eager to get them back. He's eager to get on with this. I think he realizes the huge mistake that he's made in this.
Where will you be working? And will I strike that? What will you be doing for employment?
Right now, I'm a graduate of South Texas College for diesel technician. There's one opening for Corpus Christi. I don't know how that will work with GPS, but there's an oil field out there that's willing to hire me as a private contractor. And then I'm also working with re-entry for things like and I'm just waiting to get to work. I'm not being picky either. Like Stevenson's or Kielbasa, they're all within the same pay rate from $18 to $21 an hour. So,
Right, so if you're seeking to get your children back, it may be slightly difficult to do that from Corpus Christi, but that's up for you and your attorney to decide. Who's your Child Protective Services attorney?
it is, I can't remember his name.
That's something you should have on speed dial because it's involving your children.
Yes.
When is your next hearing?
I just met him. The next hearing is set like next year. Yeah, we're just getting the kids back. We're not being.
No, how's somebody giving you children back and you're testing positive for methamphetamine? And who is we?
I mean, me, my mother.
Let me have you raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, you are.
All right, you can lower your hand. State your name for the record.
Roland Davis.
Now, when you say we are getting the children back, who is we?
I have my mother, who's been a big part of court here lately. She came back into my life. She has been having some medical issues. Like she's a quadriplegic. That's the only reason why she didn't take the kids in right now. But she's starting to move around.
Let's call them children because kids are baby goats.
Oh,
Yeah, so let's refer to them as children.
okay.
All right. So here's my question. If you are the parent legally and your rights have not been terminated, and if you're saying we're getting the children back, the we who's getting the children back is not you and your mother. The we is just your mother, because I don't think Child Protective Services, and I know your attorney has done Child Protective Services cases, I believe. No, you have not.
I have not, Your Honor. I'm sorry.
Well, that's okay. But you've been on the civil side.
I have, yes.
But in Child Protective Services Court, if they are giving the children back to anyone, they're not giving them back to you because you're in custody. and you have a meth problem. So they're not going back to you. So do you have an open CPS case? Because CPS doesn't set a hearing for a year from now. A year from now is you have a year to work your service plan. And then if you, unless there's good cause to extend, it doesn't get extended. It goes to trial. So what is this? They reset my case for a year.
I have a service plan upon release. Upon release.
All right, so your next court date is not a year from now. You need to find out when your court date is.
Yes, Your Honor.
And I can tell you right now, if your children are being placed with your mom, that means that you cannot live there because CPS is placing your children with your mom under the assumption that you are not having contact with them because they don't want somebody who's using meth to have contact with children, at least unsupervised. All right, this is what the court is going to do. The court will deny the motion, find violation of condition number 2 true, alternate main conditions to include CPS compliance. With him, I'm going to want the UA hotline until further notice. And I see where you've missed reporting. Don't miss reporting again. Do you understand?
Yes, Your Honor.
I'm going to want field visits 2 times per month. In probation, you can count the field visits as reporting if you want to. And I'm going to ask for parenting classes. If Child Protective Services gives him parenting classes, then those can count for the parenting classes. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And you both are requesting GPS. We'll do partial GPS. And that will be for employment and CPS services. And we'll do an evaluation for DDRF. Are they able to do that out of custody?
Yes, Your Honor.
So that will be out of custody and the MRT. Is there anything else he needs probation?
If the DRF is not, isn't qualified for the DRF, we are asking for an instance of outpatient treatment, monthly analysis.
All right, so we will do that. And if CPS is giving him treatment, then their treatment can count.
Yes, Your Honor.
So we'll do intensive outpatient treatment through probation or CPS. Is there anything else, probation?
No, Your Honor.
Mr. Davis, is there anything else you need from the court to be successful?
Yeah, we'll work, Your Honor. Thank you.
All right, we can go off the record. Mr. Davis, you need to make a decision on what you wish to do with the rest of your life. If your plans are to be in your children's life, then you must do what needs to be done. Do you understand?
Yes, Your Honor.
If you're not going to be present in your children's life, don't be that parent who flitters in, makes promises, the children think it's great, it goes great for 2 weeks or a month, and then next thing you know, dad is saying he's going to be someplace he's supposed to be and he doesn't show up. And it's the same thing with Child Protective Services. They have visitation for you. I know sometimes it's not as much visitation as people want, but I've had clients before, their visitation was once a month and they wouldn't even show up for that. So don't be that parent, okay? All right, good luck to you.
Thank you, Your Honor. Maybe.
Sure. Yes. Yes. Thank you. All right, and could I see one of the prosecutors. I don't know, which. Yes, there you go. I don't know which side of the aisle that goes to. Deputy Laura, it feels like a Monday. Like a Monday times 3 or 4. Am I the only one who feels that way? All right, Samantha Richards. See, you walk away and it's already being called.
I've been told not to turn my back on.
How are you doing today?
Very well. Pardon my voice, I had some kind of spicy Italian food last night. And this is how I woke up.
Does Italian make spicy Italian food?
This was every penny with sliced mushrooms and peppers and onions and sausage.
I will take that back because I've had something by them that's called the Diablo or something. It was very good.
Sounds hot.
Yeah. But then I'm from Louisiana, so it really wasn't that hot.
Well, I'm from Rhode Island, and it was.
But was it good?
Oh, it was great. It was not worth,
You will have to let me know where you were so I can try it out.
The garlic, purple garlic.
Purple garlic. You know, another one of my friends told me about the purple garlic. I'm gonna have to look into that.
It is an exceptional Italian restaurant,
Oh,
but you do have to watch one thing.
you have to do what?
You have to watch one thing.
What?
When they serve you a Cabernet wine, they take it out of the refrigerator.
Well, see, I would have to be concerned about that if I drank, but
I know.
I'm good. So as long as but I do want the Sprite taken out of the.
And it's, the food is exceptional. My wife is especially taken with the eggplant parmesan. Because she says it's the first place she's gone to for that tastes like eggplant.
Yeah. Well, okay, so
Trial.
do they have more than one location?
No, they had one previously and it closed. This one is San Pedro Avenue. Something about 17,000 or 18,000.
Okay, I'm gonna have to look into that. All right, so we're here on Valentine's Day. We were here for jury trial, but of course, we're currently in a trial. So have you conferred with the state on the jury trial date?
Yes.
I think, probably that April 11th page.
All right.
I'm gonna let her know.
Okay. Ms. Ferguson, on Samantha Richards, can we do April 11th for jury trial? All right, so you're gonna come back on April 11th. That's your jury trial date. Your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thanks for dressing appropriately for court.
Your Honor, my client has had the GPS monitor on for an awful long time. She has had no violations. It's on tracking only now. We waived the fee, but it's still a very inhibiting factor. And I would ask the court to consider it. I talked to the prosecution as opposed to it because her alleged victim is uncomfortable.
All right, so let's do this. Your jury trial date is going to be April, but counsel, if you file a motion for that, we can have a hearing on it.
I will do that.
All right, thank you. And you can just let us know when you want that motion set and just confer with the state. I know you already have, and we'll set it. All right, so the people we have left, we have Joe Sternberg, Tracy Franklin on Mr. Scott, and we need Timothy Hernandez on with Valentina Kogat. Where is she? And Mr. Goins on Michael Ruano. What happened with Michael Ruano? Okay. All right, so if we can call Mr. Steinberg and Mr. I'm sorry, Miss Gogut. And I think we may need to order. Yes, who is this? Okay. Who is this attorney? Who? Okay. Well, if his attorney doesn't, I don't think his attorney is coming back because your attorney is in mediation. Yeah, so we will bring him back on Monday. Tuesday, I'm sorry, holiday. All right, are you able to put him on Wednesday? Oh, that is true. All right, call Mr. Apollinar. I'm sorry, Mr. Raymond Bell.
I'm sorry.
Call Mr. Bell.
He's in mediation. I already called the secretary. They're asking for.
Okay. All right, your case will be reset. And you'll remain in custody. Yes, you can come forward. Yes, yes. What is your, oh, no, don't. Yeah.
And due to the fact that I was here yesterday and I showed up today, even though I know it was late. Sorry about that, but I had no control over the car problems I had over here, so I had to run over here a couple blocks over there from I-37.
Can you hold him for this afternoon? They'll hold you for the afternoon. You're welcome. All right, did Timothy Hernandez make an appearance? Timothy Hernandez.
I just tried to get a hold of.
No, but did her client make an appearance?
No, Your Honor.
Okay. All right, the board is going on its lunch break. And we will be back if the jury comes back before then.